the last word on legislative drafting. P.K Malhotra, sir, will take the dais now, and I take the backstage. Over to you, P.K. sir. Thank you so much for joining today.
Thank you. Thank you very much. Good morning to all the participants of this program. And I feel privileged to be in this panel with the distinguished panelists who have excelled in their own field and who are doing or making a good contribution in the field. I'm really thankful to the National Legal Summit organizers for giving me this opportunity to share my thoughts on a very important topic, that is the pendency of cases and their socio-economic implications. So once we are talking about the pendency of cases, we are talking about the criminal cases as well as the civil cases. And of course, as I'm the person who is supposed to initiate the discussion and I'm the first speaker, I think it's my duty and that I must inform you all about the latest pendency which we have in the courts. I got this figure from the National Judicial Data Grid, and the figures are of 1st July 2020. In the Supreme Court, we have pendency of 72,062 cases. In the High Courts, which are 25 in numbers, we have pendency of 59,57,454 cases. And in the district courts, we have pendency of 4,22,47,417 cases. And if you take out a total, the total number of pendency in all the courts comes to 4,82,76,933. And mind it, this pendency doesn't include the pendency of cases in the various tribunals which have been constituted either by the central government or the state government. So if you take that pendency into account, I think the figure becomes mind-boggling figure. And to deal with these cases, the number of judicial officers, I'm talking of the judges in the courts, again, the figures have been taken from the National Judicial Data Grid, and the figures are as on 1st July 2022. In the Supreme Court, we have a total strength of 34, out of which 32 are in position. There are 2 posts lying vacant. In the High Court, 25 High Courts, the total sanctioned strength is 1,108, out of which 708 are filled up vacancy and about 400 posts are lying vacant. And in the District Court, the figure given is 19,929 sanctioned posts, out of which 18,746 are filled up and 1,183 posts are lying vacant. Now, if you look at this scenario, the number of judges and the pendency which you have, as per the information I have with me, the judge population ratio in our country is somewhere 20 judges per million population, whereas in the developed world, the figure is well between 80 to 100 per million. So if you look at this figure, I remember one of the Kerala High Court judge having made a comment, if the kind of procedure which we are following today and the judge's strength remains the same, and if no new cases are added, it will take us 100 years to clear this pending backlog of cases. If that is the situation, you can very well understand what is the situation which is prevailing in our country with regard to the pendency of cases. And I think the Law Commission has also done some study on it, and it gave a report in 2015 when I was also a member of the Law Commission in my capacity ex officio as Law Secretary to the Government of India at that time. And we have submitted a report as to how this pendency is to be tackled. But I think when I'm talking of the pendency of cases, I think pendency normally we understand right from the day one when a case is filed, we treat it as a pending case. So I think that there is a need to segregate the cases which normally can be disposed of and are disposed of expeditiously and cases which remain pending for a very long time. I think if a case is disposed of within a year or two, probably you can't call it in this form of the pendency which we are talking of. We are talking of cases which are pending for decades. And I'll give you one example. When I passed out law, a colleague of mine, a friend of mine who did law with me, at the age of 23, he qualified the Delhi Judicial Service Examination as was appointed as sub-judge in Delhi. And within a month, there was a news item in the paper that a 23-year judge decides a case which was pending for 30 years. So a case which was filed 7 years before his birth was decided by this young judge. So if that is the situation, I'm talking of 70s, now the situation has got from bad to worse. Now we are talking of pendency of more than 5 crore. Prior to COVID-19, I think this figure was constantly between 3 to 3.5 crore. For almost 15 years, the figure used to be 3 to 3.5 crore, which has now gone to 5 crore because of the COVID. Yes, fortunately, because of the use of technology, the justice delivery system went on, although not to the satisfaction of everyone, but at least those whom we call as haves, not necessarily the have-nots. For the haves, the justice delivery system was working and probably orders were being passed. But at the ground level, even in most of the high courts also, only urgent matters were being taken up and the routine cases were not taken up, which resulted in such a huge pendency. Now, this in spite of the fact that the strength of the judges have been increased. I remember it was way back in, if I correctly remember, 14, yes, perhaps 14, when a direction has gone from the central government to all the state governments saying that in case the state governments are in a position to provide infrastructure for the high courts, we are willing to increase the strength of judges by 25% so that the pendency can be reduced. But unfortunately, most of the state government, they were not in a position to provide that kind of infrastructure, and therefore the judges' strength could not be increased to the extent it was promised by the central government. Now, what is the effect of this? If I'm talking of the criminal cases, what happens in criminal cases? The under trials, their number in the jails is increasing, and the jail population, 80% of the jail population, this is the figure quoted recently by the Chief Justice in one of his speeches given on one of the public platforms, that 80% of the prisoners are under trials in the jail. I think that situation by anybody cannot be appreciated, and this may not be situation anywhere else in the world. Why this is happening? There are many reasons for it. And the reasons are that, of course, why this under trials are so number is so large. Number one, the judges are not judges are reluctant to grant bail, and most of the time the judges will say no, let him as an under trial undergo the imprisonment, because that is the maximum, that is a punishment which actually he is undergoing, because after the trial he may be left free for want of evidence for some other reason. That is one thing. Secondly, the basic principle which have been taught to all of us in the law college, that bail and not the jail is the rule, is followed only in letter and not in spirit. When it comes to implementation, generally people are sent to jail, they are not given bail. That is one. And on this also, the Supreme Court has recently adversely commented and said that the spirit of the law should be followed. And not only that, in addition to that, they have said the government should come out with an independent law to deal with bails. So I think that's a good suggestion made by the government. But I personally feel that even if there is no separate law, the instructions or the guidelines which have been issued by the Supreme Court from time to time, if they are consolidated and circulated to all the state government and all the investigating agencies and they are properly followed, probably we can deal with the situation and it will not go beyond our control. I share another experience with you when I was participating in one such debate like the one which we are participating today. A very interesting development we discussed. One of my own colleague or a friend who did law with me and joined the judiciary. He was working as a district judge, and he shared with me. And on the lighter side of it, although he said it on the lighter side, but what is said, it has got a lot of sense. What is said that in the judiciary, there are three types of judges when it comes to granting of bail. Number one, there are judges who will strictly follow the law and deal the case on merits. And whether the bail should be granted or not, they will take a decision on this. Number of such judges is only 20%. 40% are such who will say, there is a high court above me, administrative judge will be coming and examining me, and if I am granting the bail in large number of cases, I will be seen as a very liberal judge. There may be adverse comment by the judge, and my promotion avenues may be affected. Therefore, I will not grant bail. Let him go to the high court or let him go to the session court and get the bail there. 40% of the judges fall in that category. And the last 40% are such judges. This, he was talking about the lower judiciary. Last 40% are such judges who will say because of delays, the evidences will vanish. The evidences will not be available. The record will vanish. And it will take about 10 to 15 years in prosecuting this particular case. Therefore, whatever punishment he is undergoing as an under trial, that itself is a punishment. So let him be in the jail, and therefore I will not grant the bail. I don't know how far this situation is correct, but coming from the mouth of a person who himself is a judge and responsible for granting bail, it means it has some relevance even in the system today. Because in the judiciary, all people, although they owe the oath of allegiance to the Constitution, and they are required to uphold the constitutional provision. But when it came to the practical aspect, they are also concerned about their service. They are also concerned about their promotion. And many a time there are judges who will talk about this particular thing, that knowing fully well what the judicial system is, and because of delay, even a person who has committed a crime will be left free by the court for want of evidence after 15 or 20 years. Therefore, they are strict and they are not granting bail. So I think in this scenario, probably, yes, we need a law for grant of bail. But if that is not possible, at least the instructions which have been given by the Supreme Court from time to time, they should be followed by all the high courts and even by the district court, session court, as well as the lower courts while dealing with this kind of matter. Criminal justice system in our country, it is said that it has not done to the best of ability which it could have done. And the reason, of course, is the strength of the judges is one. Then obviously, the way some of our counsels, they try to delay the prosecution cases. And I think the judges have to be strict in such matters. Now, I'll come to the criminal cases a little later, more aspect of this little later. Now, talking about the civil cases, situation is also not very congenial. We know that of course, in the ease of doing business, our position has increased. And the figures which I was noting before coming here, that in the world ranking in the ease of doing business, our position among 191 countries in 2014 was 142 among 190 countries. In 2015, it improved to 130. In 2017, it increased to 100. In 2018, we were 77 among 190 countries. And in 2019, we were 63 in the ease of doing business. Credit to the steps taken by the government during last 5 years from 14 to 19, that in the ease of doing business, our ranking increased and we were able to attract little more foreign direct investment and multinational companies started coming. Unfortunately, in the area of enforcement of contract, which is a very important aspect of ease of doing business, our position has remained stagnant at 163 out of 190 countries. And if enforcement of contracts is not as good as it is in other parts of the world or in the developed world, then I think the kind of foreign direct investment which we are looking for the economic growth of the country probably becomes only a dream. And unwarranted delays in completion of proceedings, leading to backlogs and delays of resolution of claims and cases, in spite of the fact that we have tried to promote ADR mechanism in a big way by passing the Arbitration and Conciliation Act of 1996 and further amending it in 2015 and 2019, and also by passing the Commercial Courts Act for dedicated court to deal with commercial disputes at the district level, at the High Court level, and even in the Supreme Court level, has not brought the desired result. I think what needs to be done? What are the areas which really affected? And whether by simply increasing the strength of judges, we are going to improve the situation? I think the answer is big no. Simply by increasing the strength of judges, I don't think is going to be a solution to really reduce the pendency, unless a proper infrastructure is also developed and we do more and more use of the artificial intelligence as well as technology in the justice delivery system. No doubt, large number of steps have been taken. E-courts are also working. Thanks to the technology that during COVID-19 period, it is only because we started functioning of the courts through video conferencing that some of the cases could be taken up and people's fundamental rights would also be protected. And but for this kind of system, it would not have been possible. But I just want to flag one more issue with regard to the use of information and communication technology in justice delivery system. You see, the process started way back in 1995 when Justice Lahoti was the Chief Justice of India, and he started all this process. From 1995 to 2005, every High Court was working in silos, and probably in the district administration, you only had the laptop or the computer, nothing beyond that. It is only thereafter that it has taken speed. After 2005, it has taken speed. And it is only because then probably with the convergence of technology and even High Courts websites being connected to the other High Courts, probably it became little convenient. But still the justice delivery system was only one-sided in a way that as a court, I can convey the message. Well, this is the order passed. This is the cause list. But from the, if as a litigant, I want to get some information, it was very difficult for me to get that kind of information. And I have to again approach my counsel that what is the latest status, when my case is likely to come up. So probably there was better use of information technology required. And that process has started only about, I can say, 5 to 7 years back. And in that direction, one point which I would like to highlight here is, I think most of us, more particularly the panelists sitting here may be knowing that under the chairmanship of Justice Bobde, when he was the Chief Justice of India, the Supreme Court developed a software with the name SUPACE, where on experiment basis, it was said that by using artificial intelligence, criminal appeals in Bombay High Court and Delhi High Court will be examined through this by using artificial intelligence through this software SUPACE, and all the facts of the case will be collated, all the research will be done where case law will be given, and after this summary is prepared, which was generally done by the researcher, the judge will be passing a final decision. So judge's job will be only to take a final call and pass a final order, giving his decision based on the facts and the case law which have been quoted through by use of this artificial intelligence and this software of SUPACE which has been developed. I have yet to get the results as to how this system is working. But I think in the time to come, in case this is successful, maybe in many of the appeals we can do it. I remember when I was a member of the Income Tax Appellate Tribunal way back in 2003, 2004. One of the senior advocate who was arguing a matter before me, he shared his experience of Singapore. And he said that in tax matter, when I went to Singapore to argue a matter, I gave my arguments, the other side gave his argument. And by evening, we got the judgment from the judge because he was using technology like the system, SUPACE system I'm talking of. Probably this kind of technology or this type of systems were being used by Singapore way back in 2005 and 6. And we are using it today, but better late than never, we have started it. And I think it is going to help us in a big way. In addition to this, I think if we are talking about the pendency and justice delivery system, which has affected, and we are talking about the foreign direct investment also, in spite of the fact that we have laid down timelines in most of the recent legislations which have been passed, unfortunately, we are not able to adhere to those timelines, either because the number of cases is too large and the judges doesn't have that much time at their disposal to deal with those matters, or probably the advocates who are appearing on behalf of the parties are not that cooperative with the system and they seek unnecessarily adjournment. I think judges have to be very strict on that particular area, which is not happening. And if that happens, probably some sense of discipline in the working of the courts can be brought. Here I can quote another incident. I distinctly remember when I'm talking of the use of artificial intelligence as well as use of technology in justice delivery system. I was attending a function where most of the judges were also there, Prime Minister was also there, and Minister of Law was also there. And we were informally discussing among ourselves that how to reduce this pendency, what are the ways. So one of the suggestions I made in that gathering was that, like you are direct telecasting the proceedings of the Lok Sabha and Rajya Sabha, why don't we start direct telecast of the court proceedings also? What will happen? The unnecessarily argument which are being by the consuls will not be made because they are being watched throughout the country. And probably the courts will be sitting, more particularly the lower courts, because I find in the High Court and the Supreme Court, normally they are sitting till late evening. But in lower courts, many a time, they wind up by 12, 12:30, they don't sit in the afternoon. So at least they will be sitting for longer duration. And probably because of this sense of discipline, they will be devoting more time. And probably unnecessarily arguments can also be curtailed and judgment delivery will be quicker. But some of the judges who were just standing and participating in that discussion, they said, no, this cannot happen. This was in 2015-16. But what happened in 2019 when COVID came? By perforce, I mean, it was COVID became a blessing in disguise for us, where actually we started more use of technology in justice delivery system. So sometime when there is a crisis, we find out new solution. So similarly, when making legislation, the government started laying down timelines for disposal of cases. Probably at the same time, the other things which should have been taken were not done. And therefore, the timelines are not being adhered to. Take, for example, cases under the Insolvency and Bankruptcy Code. There are hardly any case which is decided within the timeline laid down. Most of the cases are delayed. Similarly, about the arbitration cases, the timelines have been laid down, but unfortunately, arbitration cases are not decided within those timelines. Similarly, under the Commercial Courts Act of 2015, the timelines were laid down, but those timelines are not being followed. In the Consumer Protection Act, similar kind of timelines have been laid down. So I think this is a step in the right direction, but to give effect to this particular step so that the spirit of the law is continued and carried out, probably there is a need to carry out other reforms also by increasing the strength of the judges, as well as by increasing the infrastructure, as well as by use of information technology for disposal of cases and use of ADR mechanism more as compared to the normal litigation system. Now, I draw attention of the participants to Section 89 of the Code of Civil Procedure, which was incorporated way back in 2002. Initially, some of the judges in the lower courts were not even aware about it and they were not enforcing it. But after advocacy, after awareness, after training, when they started enforcing us, I think some of the cases are now going to the mediation centers which have been created at the district level, at the High Court level, at the Supreme Court level, and the decisions is becoming much quicker. Similarly, we have followed the system of Lok Adalat under the statute, the Legal Services Authorities Act, where Lakhs of cases are decided in the Lok Adalat. So because of that, we are helping the judiciary to contain its pendency and devote more time on cases where legal interpretation is required, and routine matter which can be settled either by way of give and take in commercial matters under ADR, or small disputes like MCD, family courts, and other things which can be settled through mediation. Infrastructure has been created. I think steps are being taken in the right direction. We are moving in the right direction, but a lot still needs to be done. More quicker we do, better it is. If we really want to reduce the pendency of under trial, again, here I'm reminded of another instance when I was a law secretary, and at that time, my law minister received an anonymous complaint from the hard jail inmates. And it said this is being made on behalf of 450 under trials who have been booked under section 498A of the IPC, that is under the dowry matters. And in dowry cases, you know what happens? The woman makes a complaint against all the family members, the husband, the brother of the husband, the sister of the husband, jija, father-in-law, mother-in-law, everybody is booked. And because the offenses are non-bailable, they are put behind bar and they remain there for months together. So this representation was on their behalf, and it was said some of them have already been granted bail. But because of their socio-economic position, probably what is happening, that they are not being released because either they are not able to give the surety which has been provided, which has been laid down, or the personal bond which is required. They are not in a position to say how this personal bond can be given. So my law minister called me and he said, Mr. Malhotra, what we can do in this case. And the second thing he said to me, of course, I know as a bureaucrat, you will say, sir, this is a matter which is to be dealt with Ministry of Home Affairs. Let us send the representation to Ministry of Home Affairs and let them deal with this matter. He said, this is not a matter with, yes, we should assist the Home Ministry, but we should give some way out also. So immediately a thought came to my mind, why not to use the services of Legal Service Authority? And because Legal Service Authority is meant for that purpose only. So the advocates who are enrolled on the panel of the Legal Service Authority, they can be deputed to the jail, can verify the facts of each case, and wherever there are genuine cases and can be released on bail, can be released on personal bond, they should be held in this matter. And surprisingly, you will find when we wrote to the National Legal Service Authority, the matter was given to the District Legal Service Authority in Delhi. Some lawyers visited, and out of them, about 150 to 160 were released on bail within a period of 1 month. So if there is a will, there is a way. Ways are available even within the existing legal system itself. Only thing is we have to find out a way out, how best to make use of that legal system. So through this platform, I think in justice delivery system, maybe our younger generation can play a better role as compared to the seniors, because seniors are tuned to a particular system, and probably many of them still feel that their interest will be best subserved in case they delay the matter instead of quick disposal of the matter. And of course, I mean, all of us have heard that joke, and I'm repeating that joke on this platform also, that a senior man like me, who was in practice for 30, 40 years or 45 years, spending all his life time in the field of law, he was handling a matter for the last 20 years. And his son joined the profession, his chamber, and he said, son, I have been handling this matter for the last 20 years. Today I have called the client, you discuss the matter with him, and let us see how to proceed with it. Then you brief me what is to be done. So in the evening, the son came to the dad's chamber and said, sir, I discussed with the client. The matter has been sorted out. Tomorrow an application will be made in the court and the matter will be settled. He said, fool, what have you done? We could have carried on with this matter for another 10 years and earned a lot of money for the marriage of your sister. So if you are having that kind of approach, of course, it is a joke. It's not a reality, but there is a message in this too. The reality is today we expect from the younger generation who is more tech savvy, who knows the law much better, who has got more avenues at their disposal to explore the legal position, as well as to place the facts in a better way and in a shortened time by using technology to see that the justice is delivered. You see, those who are well off, for them, justice is not a problem. They can buy justice, they can hire the top lawyers and can justice within days. We have been seeing such type of cases. But we as a lawyer, it is our duty to see that people who can't spend so much money or to whom the justice is not accessible because of their social and economic condition, what best we can do. And this kind of platforms are important for dealing this kind of situation. So I think we have other panelists also. Of course, I know I have still more time, but instead of consuming all time right now, I'll reserve my right to use this time later on during the discussion and to answer some of the questions. So I give a full stop to my talk here, leaving the floor open in case you want to ask questions right now, or after the other panelists have spoken, maybe then I will be happy to answer any of the questions which are asked to me. Thank you very much. Thanks for your attention.
Sir, we will be asking questions. We have, I told you the special interjection by Mr. B.B. Mishra. If he has any questions, he can ask. And after that, I also have a bunch of questions. I was noting down a lot of what you said, especially in terms of the CRPC and the comparison with the better off developed world. But let's go to B.B. Mishra first. Sir, if you have any questions.
Yeah. Not a question, but a small observation. Sir, when you said that you have to increase the number of judges and provide them better infrastructure so that the disposal improves and pendency gets reduced, can we not also add a reduction of vacations for the higher courts as a means of achieving more of judicial time to improve the pendency situation? I don't know, other than the education department, nobody else gets these vacations. Incidentally, the lower judiciary also doesn't get the vacation. Why should I don't understand the raison d'etre of the vacation for the judges. If you can't get rid of it altogether, at least reduce it. That's my observation, not a question.
Mishraji, I think your observation is very valid and there has been a lot of debate on it. When you talk to the judges, they say, don't think that we are working from 10 to 5 like other people work in the office. Probably we have to hear the cases in the court, then go through all these briefs later in the evening, prepare for the next day cases in the evening, write judgment, which we are doing. And if we don't get time like this, as we get in vacation, the bigger cases where we have to deal with the bigger issues involving the society at large, probably we won't be having enough time at our disposal. That is the argument which is being given by them. And then they also say that obviously once you are working 24/7 as a judge, probably you need little time for relaxation also, for rejuvenation also. So I think for that, probably vacation they feel is a must. But yes, I think majority of the people who are non-judges, they always feel that if other people can also work, take for example, the police force, they also work 24/7, or the essential services, those who are entering, they also work 24/7. So they always say, okay, well, either the vacation should be reduced or it should be like you have it in another department. You talked about the teacher are also getting vacation, I think for 2 months or for during the Dasara vacation or Christmas vacation, they also get the vacation. So this system, this is entrenched in the system for a very long time. And if you really want to change a very long time established practice, probably you need a big heart. And probably I think those judges have to show that big heart, and that I think decision has to come from the apex court, not from anybody else.
No,
I
absolutely.
agree with the observations which you have made.
Yes, absolutely, sir. Okay, sir. So I will ask my question now, but I just had a comment to make. So slowly and steadily, the speech turned into an expose, yeah? And I really love the way you put out all your points, and there's a reason you're called the last word on legislative drafting, sir. But I had a question related to the CRPC aspect as well. Obviously, there is obviously a constant loop as to the Section 41 as well, Section 41 clause A of the CRPC, and it's constantly been under problematic considerations. Even I think the Chief Justice spoke about the different aspects that is related to it. But sir, you talked about a specific bail guideline for the current, even in the current system, either you could have a specific bail guideline or implement the existing laws. Now my first question is, which of these two would you prefer better? Because obviously there is an existing law, right? And it is the failure of the implementation of the law rather than a specific guideline which creates more problems. This is my belief. And my second question is that you made a comparison with the external countries, like you talked about Singapore. There's obviously in UK and US, we have specific bails and regulations and guidelines. Sir, what do you feel that we specifically can inherit, as in what can be the content of that specific guideline, which can enhance and fasten the process of this pendency of cases, sir?
I think I'll take the second question first. And of course, we do make comparison not only in this particular matter, but more particularly in arbitration matter, where we say that in spite of our best efforts, we have not been able to promote India as a seat of arbitration or hub of arbitration. And Singapore, Hong Kong, and London are preferred places. I think many a time I feel this comparison is not correct also. For the simple reason, you can't compare India with Singapore or UK and see the size, see the economic and social disparity, see the requirements of different section of the society. Are the situations similar in our country and in that country? But when you have to learn lesson from the successes of other countries, I think we must learn those lessons. And if there are certain things which we can adopt, we must adopt those good practices. Nothing wrong in getting out of good practices which are being followed by other countries. And take, for example, even our own constitution. When we drafted our constitution, many of the things were borrowed from the various constitution of other countries. But because it is a peculiar, look at the preamble, the kind of preamble which we have. Show me preamble, this kind of preamble in any other constitution, you won't find it. Like for the right to equality, the way our Supreme Court has defined right of life, the way our Supreme Court has interpreted Article 21, there is hardly any this kind of interpretation in other countries. And most of the countries, even UK court and US courts, are now citing the judgments given by the Supreme Court of India. So that way we are doing wonderfully well. But but the fact remains that because of this economic and social disparity, the kind of justice delivery system which we are expecting for the common man, we have not been able to do much in that direction in spite of our best efforts. What best can be done? So far as the bail provision are concerned, and you said, you had a doubt about whether a new law will be a better proposition or implementation of the law is a better proposition. I personally feel, the way, I'm sorry to say, many a time when the legislature, some of the laws are being passed by them without debate in the House. I think that doesn't send a good signal for the common man. Because even Chief Justice has also commented on this. If a law is passed without a debate, when its constitutional validity is challenged before the court, we won't be able to know why this law was brought and what were the opposition to this. And today also, when a constitution is to be interpreted, the Supreme Court always rely on the constitutional debate why this particular provision was incorporated. So I think debate is a must. Law should be passed after debate, that should be available. But passing of law itself is not enough. Take, for example, when I was secretary in the legislative department, when this Nirbhaya case took place in 2012 in Delhi. And we were amending the criminal law. And Criminal Law Amendment Act 2013 was passed. Stringent provisions were made. But in spite of the fact that the country has made stringent provision in this particular aspect, more particularly with regard to rape law, and few new offenses were also created, Has the situation really improved? I think it is the implementation of the law which is more important. If there is a quick justice delivery system, it becomes more important than it. Now, I draw your attention again to section 436A. I was talking about the bail. 436 of the CRPC, which was incorporated in 2006 by the Act 25 of 2005. And it specifically provided that if an under trial has undergone half of the period of the total punishment prescribed for an offense, the court should release him on bail. Are we really following that provision? If the courts are following this provision itself, 436A, I think when I'm saying that 80% of the prison population is under trial, maybe you will be able to reduce at least 15 to 20% of that. And the Supreme Court itself has said that it is not necessary that the accused must move a bail application. It is the duty of the court, because you have to enforce fundamental right of an individual, Article 21, which is a fundamental right of the individual. And it is more relevant for the people who are socially and economically weaker section or who cannot protect their own right. So I think implementation of the law is more important as compared to making the law. Yes, making of law is necessary.
Absolutely.
Because there will be a sanction behind it. And if there is no sanction behind it, probably enforceability of administrative guidelines become difficult.
Absolutely. No, how do you put it into force, in fact? And sir, you talked about Article 21 also. The bail, in fact, granting of bail was considered as an indispensable right under Article 21. I think it was upheld in the Sanjay Dutt's case as well. And it's been often brought into light. Sir, thank you for your words. We'll come back to you. You can obviously, even though B.V. Mishra sir is the special interjector per se, you can obviously ask questions whenever you feel like.
Yeah, that was it from P.K Malhotra's side. और लाइक शेयर कमेंट सब्सक्राइब करना मत भूलना. अभी उनके इंटरजेक्शंस भी आने वाले हैं और बहुत ही इंटरेस्टिंग और भी स्पीचेस आने वाले हैं. तो स्टे ट्यून्ड. और मुझे तो बहुत ही मजा आया. आई होप यू गाइज ऑल्सो एंजॉयड इट. थैंक यू सो मच फॉर वॉचिंग.